Good evening and welcome to Behind the Headlines. My name is Timothy Nyangweso. Tonight we focus on the momentous decision that was made by the Supreme Court, especially asking ourselves, is this a win, a silver lining on a cloud there, or should we be waiting for a new twist in the political playbook of this country? The 3,000 𝐒𝐻𝐿 that were arrested, the NUP supporters that were arrested, the numerous soldiers that are behind bars by the General Court Martial. What does that mean? We also look at three areas there. We look at one, the judgment. Two, we look at the president's letter. And finally, we look at the advice that comes from the Attorney General. What is the way forward, especially looking at the ping pong between 31st Jan and today? Nothing has been done. That's the biggest discussion we're having tonight. Let me introduce my panel. The panel tonight in my company is all of land friends, some of them being here for the first time. And I'll start with the lady that is immediately on my left. The lady is Helen Ndagire, who is a lawyer and works with Max. Good evening, Helen, and it's good to have you.
Good evening, Timothy. Thank you for hosting me.
Thank you very much.
Yes.
Next to Helen is Counsel Nicholas Opio, the founder of Chapter 4, Uganda, but also human rights advocate. Nick, it's good to have you again.
Well, thank you very much, Timothy, and good evening to all the viewers. When we were choosing the place to sit, I insisted on sitting next to Helen for reasons I'll explain later. But it's an honor, Helen, to share the evening with you here.
Thank you.
Thank you very much. Next to Nicholas is Professor Christopher Mbazira, who is a lawyer, but also the coordinator of the Public Interest Law Clinic. Good evening, sir, and it's good to have you.
Thank you so much, Timothy. Good evening, viewers.
Honorable Medad Lubega Segona, representing the people of Busiro East, Chairman of 𝐶𝐿𝐴. Good evening, sir, and it's good to have you.
Good evening, and it's my pleasure being here with this distinguished panel. I was not like Nicholas, who had the privilege of choosing where to sit. Probably if I had the privilege of sitting, I would have sat where you are sitting.
To ask the questions or to...
To do whichever assignment I would find there.
There is a lot of
or
assignment.
Possibly the comfort.
No problem. We'll see about that one. Lastly, but not least, Honorable Mbide Mukasa, the Vice President of the Democratic Party. Good evening, sir, and it's good to have you.
Thank you, Timothy. Good evening, viewers. I equally greet the panelists. When 𝐒𝐿𝐴 said so, I thought he was going to recite what we used to study, the transfer of heat by conduction. I am extremely happy to be here. One of the panelists incidentally told me, so I am going to be definitely speaking in such a way that somewhere, somehow, somebody is holding a marking scheme. It could be recalled.
Just to put a stick in that one, someone also sent me a message and said, since Honorable Mbide is there, please, I'm also with my dictionary waiting. So, no pressure, but it's coming.
You have just introduced Honorable Mbide. So when did you receive that?
I came with it.
I'm likely to cross-examine you.
We shall get to that one. But you can be part of the show. Go to our Twitter handle, X there. Drop your comment, hashtag UBC Behind the Headlines. The number is 0709 60 25 92 for text or WhatsApp. Or go to our YouTube channel, drop your comment there. We'll get to them in a short while. I can promise you it is going to be a fast and quick show because the intelligent people are here with me today. But also tomorrow is the 45th Terehe Sita Day. That will be celebrations out of town there. We celebrate all the men and women that liberated this country. We also see the cuts on 𝐒𝐿𝐴. That's a conversation we'll have later on where the members will make a comment. But let's jump into it as the conversation is this evening. First, the judgment came on the 31st of January. That was Friday last week. After it came out, Sunday, the signed copy was sent to the Attorney General. Monday, the Attorney General came to the floor of Parliament. Sorry, yesterday, Tuesday, came to the floor of Parliament, made a presentation and made 6 advisements that were passed on to be given. One was all pending trials before the General Court Martial would cease, but also that the General Court Martial and prisons would give a list of all civilians, and these would be transmitted to the ordinary courts. The General Court Martial would also provide a list of all UPDF members to be transferred to appropriate courts. And fourth, the DPP, under advisement, would liaise with the General Court Martial and UPDF to take over and conduct the cases. The fifth was the Uganda Police Prisons Authority, to advise, has been advised to wait for the process above and orders of competent courts. And finally, the Ministry of Defense and Veteran Affairs would introduce amendments to that effect. But also today, the Honorable Medard Ssegona and the team went to see the Chief Justice to ensure that they find out if this has arrived, but also habeas corpus was put there by some of the members of Dr. Besigye and 𝐒𝐻 team before court, the Constitutional Court there. Let's jump into the conversation. Honorable Ssegona, first and foremost, congratulations on the momentous, everyone has been waiting since 2021, and finally you delivered in 2025. The question is, what is happening right now? Because we saw you on the floor of Parliament yesterday, you and the Attorney General back and forth, but what is happening and why is this taking so long?
Well, thank you for congratulating me, but you should be congratulating Ugandans that have been saved of this scarecrow, which has been used over the years to achieve political ends, mischievous political ends, for your information. And also to congratulate the court upon standing firm to do the job bestowed unto them by the Constitution and the people of Uganda. As to what's happening, so far nobody has been released, and you have ably described the situation that we went to follow up, because we had expected that the learned Attorney General, in writing that letter to the Chief Justice, would have put us in copy to know what exactly he was communicating. Because you see, if you are two parties and the losing party decides to start communicating with the court about a matter where my client or I have an interest as a professional, then courtesy and decency would require that you put me in copy. I ought to know. Because some of the things you are proposing to do might be illegal, in my opinion, and I need to follow up. For example, when you say the DPP should liaise with the General Court Martial. First of all, the General Court Martial ceased to exist. You can only say liaise with the army, because that's where those people's files are. Number two, you cannot even ask DPP to go and liaise. DPP cannot be instructed. If you feel there is a case, actually with the decision that came up on 31st, the order says those proceedings are terminated. So there is no case. Once you terminate, there is no case. Even transfer, you must read the word transfer purposively. You cannot even transfer, because what are you transferring? Supposing the DPP looks at Nicholas Opio's case and she thinks this does not merit, I cannot proceed with it. What you do now, considering that the proceedings were illegal in the first place, you get the army leadership to liaise with the police. The police immediately starts fresh investigations, submits files carrying their findings on file to the DPP, and the DPP decides whether in the first place there is reason to charge. Two, from the time the decision was rendered, any further detention became illegal. Illegal because the court that remanded has been disbanded, and there is no saving provision in the judgment. Because unlike, I think, the Constitutional Court, I hope I'm not forgetting, had given them 2 months, the Supreme Court said with immediate effect. So you do not have any window. Now the Attorney General, in that letter, extends warrants which do not exist, actually creates new warrants by necessary interpretation. And that reminds me of those days, when I look around, apart from maybe Professor, these are the young people who were not there, when we had the Minister of Internal Affairs in this country, who had detention orders pre-signed. So one day, notorious young men, you were not there. No, I called you because you're a professor. I only feared you. We were there, you were not there. So the notorious young boys went and stole those letters, those detention orders, pre-signed. So they would just get Nyangweso, fill in your name and the date. The nearest police officer would arrest you and detain you without trial. Now what my brother 𝐒𝐻𝐿, Honorable, is doing is literally that. Because where does he get the powers to tell 𝐓𝐵𝐲𝐬, Commissioner of Prisons, that continue holding those people until you get further advice from me? First advice is not an order that can detain. So there is lack of decency or professional decency in that. We should have been put in copy. That's why we went up to the CJ's chambers to follow up and see if actually that letter is there. We confirmed it is there, but we were not given a copy, I must say. Well, you cannot fault CJ's chambers, because if the owner of the letter did not choose to copy you in, I'm only cautioning KK that that one is professional misconduct. You must put me in copy. So currently, yes, all those people continue to languish in detention illegally. And you are taking some steps, as you must have seen, at least in the case of Dr. Besigye and Haji Obeid. We're also taking steps in respect of Council Aaron Kiza. We're also taking steps in respect of our NUP supporters. For the relatives of those people who might be affected beyond that, those groups I've mentioned, they may feel free to approach us so that we could pursue also their remedies. Otherwise, they are there illegally.
Honorable, before I get to Professor Mbazira, why is it complex to implement this judgment? Why is it becoming, because you asked a question on the floor of Parliament about timelines. Why is it becoming a very complex matter to implement this judgment?
Well, it is complex, first of all, because of lack of goodwill. It's bad faith, purely bad faith. Because immediately after the judgment, you remember the tweet by one Chris Magezi?
Yes.
And Magezi means what? Magezi means intelligence, right? Wisdom. One Chris Magezi purporting to speak for the UPDF, because he said official statement of the UPDF. His first knee-jerk reaction was Besigye will not be released until and unless we receive instructions from �Yoweri the Commander-in-Chief. I remember, and then the Sun immediately, the following day came out with another tweet and said, I'm back on Twitter, on X, and then he said, Besigye will only live in two ways. The first will be in a coffin when we have fired him bullets, shot him with bullets. The second, on his knees, upon apologizing to Mzee, that apologizing to his father. Only those. So that explains the difficulty with which implementation may be met.
Professor, coming to you, when you look at this 306-page judgment and the justices that were seated there, what do you make of it?
It's a very interesting read. I was actually reading through it today. I must confess I've not read the entire 300 pages, but I was able to follow the proceedings live. So I have an idea what each of the justices said. For me, one of the most important positive outcomes of this decision is the emphasis it puts on the right to a fair trial as a non-derogable right. I think it's the first major decision to emphasize the non-derogable nature of that right. And it also goes as far as breaking down the tenets of that right in relation to the bodies that adjudicate criminal cases. It gives very detailed guidance, and it draws not just on our law here, but it also draws on international standards from different bodies, international bodies. It also draws on comparative jurisprudence from different jurisdictions. It also gives a very interesting context, our historical context. I was so excited reading the judgment, especially the judgment of the Chief Justice, and seeing references to the Odoki report, the Constitutional Commission report, because in effect the court is saying we cannot understand where we are if we don't understand where we've come from, and we cannot understand where we are going unless we understand where we are and where we are coming from. And when you look at that historical bit of it, it looks at two areas that are relevant to, that were relevant to the case. It looks at the role of the army in a very candid and open manner, you know, attributing some of the governance deficits that we've had, the rule of law deficits that we've had to the conduct of the army, and then drawing on the views of the people, what the people said when we were, you know, working on the Constitution in 1990, from 1990 to 1993, 1990, 95. And it shows how things have evolved. And it's a commitment that, you know, we don't want to go back to that history, relating it to the preamble of the Constitution, which is also very clear that it reflects on our history and it makes a commitment. In other words, the court is saying we need to break from the past, a past that has been characterized by tears, a past that has been characterized by arbitrary action from different agencies of the state. The other thing, and I hope my colleagues here, the lawyers, agree with me, is that the way the judgment is written, it is easy for a non-technical person to follow. I liked the style of writing. Even a non-lawyer, a person that has ordinary comprehension of English should be able to follow. Of course, there are some technical issues here and there, but the person should be able to follow. So I would urge all Ugandans, don't get scared of reading that judgment. It makes very interesting reading. You should be able to comprehend. It has, for those of us that are in legal academia, it has become a tool of education, material to refer to. I used it this afternoon in my criminal procedure class, and it changes the way we've been thinking about so many things. So kudos to the court, well done, Supreme Court. We appreciate. Of course, there are areas here and there that we are still not comfortable with, that we need to look into. For instance, one of the areas we know the court makes a distinction when it applies the principle of retrospectivity to say that a certain category, for a certain category, this decision is prospective. For another category, it has a retrospective effect, and it clearly defines those two categories, direct review and collateral review. There are issues there because if something is unconstitutional, it should be so ab initio. So you cannot say I was tried by a body that is unconstitutional, and then you say, but your decision does not apply to me. Of course, we appreciate the practical challenges that would have arisen from that, but nevertheless, the court should have found ways around that. For instance, it could have used the structural injunction. There are ways that the court should have gone around that, but generally, it's a very good decision, very well written.
Professor, staying with you before I come to Nick, what does this mean for constitutionalism? Because it's not the first time we're seeing what you're talking about, because Article 28(1) talks about guaranteed fair, but also a speedy trial at that. Are these tenets still holding, especially in terms of constitutionalism? Honorable 𝐒𝐮𝐻𝐫𝐿 has mentioned the people are still there and nothing is being done.
We've achieved something because previously it's like matters touching on the army were a no-go area. Of course, the Constitutional Court has tried several times, but this time the court comes out strongly in a very detailed opinion, just as I've said. But the other very important difference, and this is very important for constitutionalism, is the involvement of the public, because the public has been involved in pushing for this judgment to be delivered. You cannot have a state based on rule of law, constitutionalism if the public is indolent. We need a public that is active. We need civil society that is active. We need civic empowerment, and the events that happened before the judgment was delivered, we saw a degree, it may not be the ideal, but we saw a degree of reawakening of civic empowerment, where people were coming out and saying this judgment has delayed. It is a matter of urgency, considering what we were seeing in court, the way the lawyers were being treated, the way the accused persons were being treated, the conduct of the panel, the conduct of the judge advocate. It reawakened public involvement. So with this push, I think it needs to be sustained. Building a constitutional state is incremental. So you must appreciate every small gain and see how best to make use of it. So we've now achieved this. We now have to target what's the next area that we need to push for reforms and, to concretize what we've achieved.
Thank you very much. Nick, coming to you, the Attorney General's advice on the floor of Parliament, the President's response, and we'll come to that in a bit. What do you make of the Attorney General's advice being given there to the ruling, but also is this delaying tactic or failure to interpret what has been given as judgment?
The Honorable Segona says bad faith. The word is bad faith. Because first and foremost, the Attorney General must view himself not as the lawyer for the President or the lawyer for the executive. He is the custodian of the rule of law. He is the custodian of public interest, and at all times must act in public interest. Where public interest is at variance with the interest of a small ruling class, public interest must trump that small, narrow interest. And the work of the chambers of the Attorney General is to ensure that we implement the law as it is. If the Attorney General's chambers views itself in that light, there should not be any hesitation, any dithering, any technicality, any advice, because the ruling of the Supreme Court was really, as Prof has said, even comprehensible to a common person. Very clear and direct. The Attorney General should not be issuing any other order apart from transmitting the orders of the Supreme Court for immediate implementation. Trying to read the order of the Supreme Court and interpret it first undermines the ruling of the Supreme Court, because when the Supreme Court has spoken, nobody else should really even attempt to read into what they have said. And I think that the Attorney General should transmit that order for immediate effect and not try to give it some meaning other than the meaning that the court has ascribed to it on order. If I were in his shoes, I would immediately ask all government agencies that are responsible for implementing this order to do so now, immediately, not awaiting some advice from the Attorney General. If I were the Commissioner General of Prisons, I would be very happy to decongest my prison and send away everybody whose warrants have expired, because the Supreme Court has said those trials were illegal. So I think that the actions of the Attorney General are actions of trying to dance a delicate dance, trying to find a delicate balance, especially given the expositions of the President and those in the military circles. I think he's trying to dance a very delicate dance in that regard. And I think that in doing so, he's undermining the office of the Attorney General, but also undermining the decision of the Supreme Court.
Sticking with you, Nick, you were here and we talked about the 65 pages of the proposed amendments that were to come in, that were proposed in December, that were supposed to come in now. It's the 6th advisement that the Attorney General gives, and what Honorable Segona said about Colonel Chris Magezi and the President's letter, doesn't that put us in a very delicate place? And what is that place?
So we have two choices here. The wise choice is to implement the decision of the Supreme Court without question. and do so in absolute good faith, do so expeditiously. That is the wise thing to do. But it seems that we are also either inadvertently or advertently drifting towards a second choice, which is a choice of creating a situation of constitutional and legal crisis. Because the president's letter essentially is telling the judges off, is saying things that are in any ordinary democracy a head of state wouldn't say. So we are heading towards a path of constitutional crisis and a path of further abuse of the rights of people who have been detained on the orders of the General Court Martial. I think for me that's the unwise thing to do. The argument that they will go back to Parliament and undo the decision of the Supreme Court because they want to try civilians. The argument that the General Court Martial is responsible for peace and stability is without basis, either in law or in fact, because I don't think that this country is peaceful because of the General Court Martial. Absolutely not. So I think that the amendments in Parliament, which were proposed earlier in December, don't cover what the Supreme Court has said. If I were the Minister of Defense, who also is a lawyer, the Honorable both, I would immediately withdraw the proposed amendments of the PDF Act that's before Parliament in view of the Supreme Court ruling. I would withdraw that amendment and take back a new amendment so as to incorporate the proposals and the judgment that was delivered by the Supreme Court. The amendment before Parliament now only does seek to rectify the illegalities that has been happening in the army, namely trying to find a place for the SFC. The SFC is an illegal entity. I think that Honorable Segona and the Honorable 𝐒𝐮𝐲𝐫𝐿 have made this point in Parliament, that the SFC is illegal. What the proposed amendment brought in December sought to do or is seeking to do is to regularize that illegality, but does not in any way touch on what the court has said. So if I were the Minister of Defense, what I would do is simply withdraw that proposal and bring a new proposal that seeks to implement and not undo the decision of the Supreme Court. Because trying to undo the decision of the Supreme Court will lead us right back into another legal challenge. Because as you know, Article 92 prohibits Parliament from enacting laws to vary a judgment of the court as between the parties. The Attorney General was a party in this case. In fact, he argued this case himself, personally. He cannot be the same person to come back to Parliament, seek an amendment to undo the decision of the Supreme Court. That would be itself illegal. It would lead us back to a court challenge to that law if passed by Parliament.
Thank you. Let me come to Helen. Helen, the death sentence, when it was contested, it took a few years to be implemented. Did we as Ugandans celebrate too early for this ruling, in your thinking?
Thank you, Timothy. I would first of all like to agree with the position that this decision is one that's leading us in the right direction, and that direction is more or less promoting constitutionalism in the country, and it's very timely. And as to the question of the death penalty, I would say we didn't celebrate quite too early, because in light of this decision, we see that the court, or the Supreme Court in this case, continues to look at the non-derogability of certain rights under the Constitution, and the right to life being one of them, the right to a fair hearing. So in essence, what the decision is doing is continuing to build on the jurisprudence we have. And part of that is looking at the principles of interpretation, looking at the fact that the Constitution is a living thing that continues to progress in as far as the country's progress goes, in as far as the aspirations of the people go. So the shift in the times dictates the shift in that decision, or public interest would also play a part in the decision that would be given in this case. So I wouldn't say that it was a celebration that came a bit too early. I would say that we are continuing to see progress in regards to what our courts put forward as in terms of implementation of our laws, in terms of interpretation of our laws, and more or less we are on the right trajectory in terms of the fact that the courts not only look at what the previous decisions have held, but also look at the times and what they demand and what would be better moving forward. Yes.
Could this Supreme Court ruling, the ambiguities in there, Honorable Segona talked about timelines, especially when the Attorney General presented before Parliament. Could the ambiguities hinder the implementation that is now back and forth advisement? Nicholas talked about the Attorney General who was speaking for the case. Now he's giving advice to government. Could these ambiguities be a prevention for the implementation?
I would say that the implementation of the decision cannot come to a standstill or cannot be halted because of the ambiguities. The decision in itself is clear. There are no ambiguities as to implementation, but what is happening in the background are issues to do with administration, are issues to do with the systems in place and how they can adapt to the new decision that has been put in place. For example, when you look at the issue of transferring the cases from the General Court Martial to the other civil courts, there's a question of if the proceedings before the General Court Martial in itself have been invalidated, or if they've said that they are nullity, how do we transfer the same proceedings to the civil courts? And there's also a question in terms of human rights enforcement, for example, where under the Human Enforcement Act, they say it states that where a person has gone through proceedings and it is found or by a competent court that such proceedings have been in violation of their fundamental human rights, especially the right of fair hearing, then such proceedings should be declared void and that person should be acquitted. But in this case, we are looking at a transfer of these proceedings to another court. So there's a lot of administrative work that's happening in the background vis-a-vis bringing the decision itself home to the realities of the situation. So we can't say that the decision in itself is ambiguous since such questions were not put to the court. For example, the question on transferring the decisions or the question on whether such people should be now, whether such cases should be relitigated before the civil courts. So I would say it's not, because the other laws, the other enactments are clear. The Human Rights Act is clear, and then issues to do with transfer are also clear in our system. So I wouldn't say that the decision is ambiguous. I would just say that there's a lot of adapting to be done to what systems are in place right now to see that the progressive decision is implemented.
Thank you. Honorable Mukasambide, when you saw this judgment and saw the response of the President and then the advice of the Attorney General, what did you make of it?
Thank you. Number one, it puts me in a state where I am incapable of receiving that one judgment with extreme, almost briskly, with extreme excitement, to the extent that one would be even enticed. And I have had several comments outside where we are, pointing to the possibility that actually now Uganda is excelling in form of judicial effectiveness and efficiency. In my opinion, that would be hurried and hyperbolic in nature. Why? Because the end result of a judgment or a decision of court includes, among others, the execution of such orders of such court, the implementation of orders, whether substantive or even advisory. We are also now dealing with a country where one would ask oneself, was this judgment, what is this judgment? For example, the implementation of the decision of court, what is it waiting for? Because we are in a country led in a style that is not as normal as one would read from text to 16. For example, it looks like a decision has not yet been taken from the innermost sanctums of decision-making of state, to the extent that even a minister has no final decision available to him until the innermost kitchen cabinet sits and takes a decision in a direction that would be preferable for implementation purposes. Number two, you find that even courts now are not at liberty to divulge any going forward. Yet a decision was arrived at. The day the decision was arrived at, we received pieces of advice from several entities, even intergovernmental and multinational. Geneva, for example, the Human Rights Commissioner gave his own opinion. He said, yes, let now the country implement the orders of court that would have otherwise included, among others, a stealth transfer of a list of all of those that were affected by wrongful trials for purposes of freedoms. My professor here has also alluded to a very serious fact. That decision also is tainted with a likelihood of interpretation that fundamental human rights have got an expiry date. There are those that have suffered a decision, are serving sentences by a court, one that has been declared incompetent, illegal, very extremely partial, almost non-existent. So when a court issues a decision, it should be that kind of a decision that affects even the rights that are being violated by those that ultimately were wrongfully imprisoned on account of such makeshift courts. So to me, there is also that likelihood. We don't have an expiry date to fundamental rights, but that decision established one. So I think that should be revisited. And my professor, I associate myself with that reasoning. We must go along those lines. And also, then number two, it looks like there is some kind of enigma. It is not properly understood. For example, in this case now, the arrest of certain people, including Dr. 𝐒𝐿𝐵𝐶𝐠. Since the arrest was never understood how it was conducted, it looks like even consequent and subsequent imprisonment is clearly never understood. Who conducted the arrest, even police cannot explain, even the army cannot explain. It looks like this was done by some Gestapo of some sort, some secret paramilitary thing that actually conducted the arrest. Now it looks like they are still waiting for such orders from the same, for purposes that we can now see a concrete direction that the 𝐒𝐵𝐶𝐠 case could take. Now, the case of 𝐂𝐤𝐥𝐢𝐴𝐻, if a court is declared non-existent, how would one be held still for contempt of a non-existent court? So in my opinion, Uganda now, the goodwill is something that we would like to look at. Let the president not think, or government, that there is anybody available to defeat it on account of justice, where it has to be produced. The problem with our leadership is that it would like to establish a kind of leadership which has got an umbilical cord, which is single, reaching to a single decision maker, but having tentacles in all organs of government, irrespective of whether such organs should be within the purview of separation of powers as a doctrine. To the extent then that now it looks like there is an order that is being awaited to the extent that we can have freedoms. And so, in Africa, when you look at several countries, the effectiveness of our judicial independence here in Uganda is not mentioned even among us, the first 7 countries. Younger countries, younger than Uganda, have featured in the first 7 countries where there is judicial effectiveness and efficiency. Namibia, we are almost 30 years older than Namibia. Mauritius, around 4 to 6 years older. South Africa, it is unclear, but all of those countries feature and Uganda does not. Because we benchmark the wrongest countries. We are benchmarking Egypt on how court-martialed are actually trying civilians, benchmarking Tunisia, that civilians are actually court-martialed for insulting the president. And in my opinion, these are areas and countries where you will find a multiplicity of trips done by our own leaders in Uganda for purposes of benchmarking wrongful legislations that have definitely led Uganda into wrongful judicial path. So, a decision given by a court, access to justice has been given by our constitution, a time not more than 48 hours. If you continue to incarcerate anybody, that courts have actually within their own interpretation discovered that they are wrongfully in any other prisons, why would you wait for anything other than freeing such persons? Geneva has insisted that we must respect treaty obligations. Uganda, incidentally, is a signatory to several treaties. We have a constitution that equally also respects the principle. Yes, and even when we are looking at the national objectives and directive principles of state policy, particularly because that is part of the constitution when you look at Article 8, capital A, because it makes it part of the constitution. The pacta sunt servanda principle applies with equal force. Now, when Uganda is a signatory to the African Charter, what are you doing in terms of access to justice, improper imprisonment of persons? Uganda also prides itself in being a member to the East African Community. What are you doing under Article 6D72? So Uganda cannot be a country that quickly takes importance in signing statutory signing instruments, constitutive instruments establishing rights without respecting any. In my opinion, I think this is a governance issue. This is an issue where the government of the Republic of Uganda has to answer, and where it fails to, then we know why it does.
What does this mean as we draw closer to the political temperature come September, October, when nominations are happening, especially that NUP supporters were arrested around this season of politics? Dr. 𝐒𝐻𝐫𝐿 Besigye has been pivotal as an opposition member. What does this mean for the politics of the country?
For me, it is good that we are beginning to see the failure of implementation of a decision of court. It is this court that I do not want, in my opinion, to exaggerate whose importance, because I'm expecting that it has a decision to give early February next year.
Honorable,
now, until that decision is also given, I am not in a hurry to think that this is an independent
The same court has seen presidential petitions, and some of them haven't been, the recommendations haven't been implemented.
Yes.
Do you still have hope?
And besides, for me, I am looking at a decision where this court emerges as independent as practicable, to the extent that it can declare a nullity, an election where evidence has been given satisfactorily that an election has not been conducted in accordance to terms contemplated in the law. We haven't seen it in Uganda. We are not only waiting for it by way of axiomatic faith, but we feel there has been occasions where it should have been given, but has never. Okay. That is what I am looking forward to, established by this very court. And until that is done, for me, I am not available to celebrate, because you can imagine, even a decision of such a court has not been implemented. So I am waiting for February next year in order for me to give a celebration that this Supreme Court is really a very serious thing to give my regard.
Honorable Segona, treachery charges were slapped on Dr. 𝐒𝐻𝐫𝐿 Besigye and 𝐻𝐭 𝐺𝐢𝐴𝐺𝐠. The proposals that Nicholas has spoken about were proposed in December. When you look at what is happening here, the president said the judges don't run the country. And when you see your new supporters that were arrested, some that have come out way after, doesn't it concern you that we might be celebrating too early, yet the government has an ace to play at a later time?
Well, as Fred said, the entire governmental structure has problems. But that will not stop me from celebrating the little that I am able to pick and put in my bag. and run away with it. You know where the English say, you take your piece and go away. The Baganda say nyamantono. Ukaeneri munkwawa ngasiya kapa. So I will celebrate whatever little I'm able to celebrate. That's number one. Number two, in this very case, there was an application for a stay of execution. It was very painful for me to see a stay of execution granted by the Supreme Court, saying that even with a declaration that this is not a competent court of law, you can go ahead and still charge. And like Nicholas said, the Attorney General is not a personal attorney to Yoweri T. Museveni, but to government. The presumption and assumption are that the Attorney General will render advice in good faith, professional advice, and so on and so forth. One of the reasons why Professor 𝐒𝐮𝐫𝐿 was sacked as Attorney General was over the Mashati case. Is it called Mashati or something? Mashati case, where the president told him to pay lawyers, to sign an agreement with lawyers in Kampala to go and defend him in London. And the Professor 𝐒𝐮𝐫𝐿 said, no, sir, you have been sued in your individual capacity. Go and defend yourself. And the man said, no, I was sued over things I did as president. This one said, yes, that is going to be your defense. Actually, there were exchanges of letters. That is going to be your argument in court. But the Attorney General of Uganda, under Article 119, has not been sued. I have no business signing an agreement to pay lawyers to go and defend you. Pay them, they will go and defend you. Eventually, they will dismiss that case, you will recover costs. He was fired with the following day, within one day. And I mean here, he was fired today. A new Attorney General was appointed. Both of them are now deceased. And on the day of appointment, the next Attorney General signed an agreement to pay Ugandan lawyers the sum of 1.49 million pounds to go and defend General Museveni in London. That is payment to the Ugandan lawyers who did the liaison work. Then the barrister in London who defended him was paid a whooping sum of 164,000 pounds. Mark the words, 164,000 pounds. The people who played the liaison role were paid 1.49, close to 1.5 million pounds, not dollars, but pounds. So the way General Museveni runs this country is like it's a personal enterprise. First of all, he has personal anger that you will see through his son's tweets. Said, this man wanted to kill my father of 80 years. First of all, even 80 is the conservative calculation after tampering with the age meter. Two, that it is now, the man feels a duty incumbent on him personally because he's not defending. Well, I fight to defend himself. Oh, yes, and obviously. I obviously do not want to see someone killing General Museveni because that might bring a curse onto the country. You kill a man of 80 years who cannot even run after dark. I would find it difficult to accept that. But General 𝐒𝐨𝐻𝐼𝐺𝐢𝐺𝐠 is not defending the president of the country. He's using state machinery in defense of his father. And he says, for this, we shall get 𝐓𝐵𝐺𝐢𝐺𝐢, drive him to Gulu, tie him on a tree in Gulu. I don't know why Gulu. I don't know whether it is an act of witchcraft or something.
Where they used to do fire and sport when they first came to power. Good. As a child, I witnessed them do
so,
that.
Nicholas knows, but I actually thought it was witchcraft. That's where the witch could have told them.
They used to tie people on particular trees.
As we speak, we don't know whether Dr. 𝐒𝐻𝐫𝐤 has already crossed Karuma en route to Gulu for execution. So somebody feels it's a duty to defend his father. So that's how he treats state machinery. Beyond that, I don't want to criticize the president's speech. One, whereas I know that the president's speech has an impact or influence over state institutions, especially after the man patronizing state institutions for the last 4 decades. For me, you know, Voltaire said, I disapprove of what you said, but I shall defend to death your right to say it. Article 29, because I cannot fight in defense of 𝐒𝐻𝐫𝐤's rights and forget about Museveni's rights, because I'm told he's also a human being, he must be protected and defended. So Article 29 protects all manner of rights, including the right of expression, and that right of expression includes expression of knowledge and expression of ignorance. So I must protect everybody that expresses himself or herself. I have no quarrel with the president's expression. My fear is where it says the country, or Uganda, is not governed by judges and lawyers. First of all, that's factual. This country is not governed by lawyers, judges, the balalo, teachers, and so on and so forth. It is governed by a constitution. Now, the Ugandans that he's talking about who vote in a referendum, who are beaten during elections, etc., whether through an act of witchcraft, whether through coercion, whether freely, enacted unto themselves a constitution. And they gave specific powers to different organs of state. Interpreting the constitution is a duty and function of the judiciary. The judiciary on this matter has spoken twice. In the Constitutional Court, through 𝐒𝐻𝐫𝐤𝐴's case, through Amon's case, and the Supreme Court has also spoken. It is incumbent on all of us to respect the decision of that court, regardless of how we feel. Nicholas and I know the cases involving the Lord Mayor of Kampala. We went before Justice Kavuma, and we had all manner of dissatisfaction with the way he conducted himself in the Lord Mayor Lukwago's case. But even then, we never disparaged court. So the words of Gen. 7, if you remember, was it over something when he said that judges are legally bankrupt? That basically they do not understand the law. I understood him in good faith to be descriptive that the judges did not know the law. Even after studying the law, qualifying under the Constitution, and he himself appointing them. He knows better law than them, even when he claims that he studied law for 1 day. And that when he read the 𝐒𝐿 case, he decided to leave the faculty of law. First of all, I insist that he has never been admitted for law. Because the process of selecting people who would go to study law is a rigorous, robust, and thorough one. It's a sieving process. Those are your words. But of course he did not qualify. That's a fact. If he qualified and was admitted, I am happy to be executed in Gulu if he brings the letter. So the point is, yes, by appointing judges that are legally bankrupt, was he a fraudster? I think away from the jokes that the president keeps bringing and putting across, even when we are dealing with serious matters that go to the root of our existence as a democracy and as a country, the president should get serious, first and foremost, and act within the purview of the law. As to what is happening now, I posed a very simple question, basic question. On whose orders are these people now in detention? I even went ahead and made proposals because I did not want to be seen as if I'm just problematic and creating anarchy in this country. First of all, there is no possibility for anarchy. There is no constitutional crisis unless General Museveni decides to create one for the country, like he has been problematic in the past. I mean, don't we have courts of law? Are they not working? They are working. Evidence of their working is in form and style of this judgment. If I were these people, I would either do the silly thing, the stupid thing they normally do. I would release Dr. Besigye and Obeid Lutale and rearrest them, hand them over to police, commence proceedings, new proceedings. Of course, there is a problem that once the proceedings are conducted and they are adjudged to have been a nullity, there is nothing you can cure in them. You cannot transfer that file. Why? Because the DPP cannot take over a file from the court martial. But there is also something practical. In the court martial, there is nothing. There are no documents. You know, when those judges, so-called, are coming into court, every day they come to court. Anyone who has been in that court will tell you. They come with somebody comes with a new file folder with blank pieces of paper. They don't even take proceedings. One day we wrote to them and asked for proceedings. We walked and walked until somebody told us, I will be honest with you, we can give you this order. We have no record. They don't have a record. The only person who attempts to write is the advisor, the judge advocate. Yet he's not a member of court, so his record is not the record of court. So there is no record to be transferred. That's number one. Number two, in military operations of this nature, you know, I have been abducted in a military operation of this nature. After moving for 8 days, we left Kampala. We traversed the entire western region.
It's a case of treason.
Yes, and in a case of treason and terrorism. On the 8th day, 7th day, they call you to record a statement. There is not even first information in their file. So they don't have files to be transferred. Indeed, there was no order to transfer prisoners. The prison, and this is my last, under the Prisons Act, Dr. Byabashiija can only detain on a valid warrant. I asked the Attorney General to explain just one simple question of legality. He did not answer it, and I agree he could not answer it because he had no answer. Dr. Besigye's warrant and Obeid expired on Monday, should have expired on Monday, had they been brought to court if we did not have this judgment on Friday. Because they were supposed to come back. It would have been renewed. So they were not brought, it was not renewed. The Supreme Court did not order detention.
Okay.
And
Thank you.
could not order because nobody asked for it.
Let me read some feedback that has come through. Hello, members. I salute you. And my question is, if one retires from the army, and does it mean he or she, his title is of being a soldier or any rank is taken away? What makes the retired soldier a civilian once a soldier remains a soldier? For example, if I am a teacher and I retire from teaching, does that mean I am no longer a teacher? Okay. Colonel Chris Magezi is a very intelligent man with his books in quotes. Can I send such a message? It affirms that the statement by Dr. Kizza Besigye that the elite are the real problem of the country. Colonel Chris forgets that many people who have been in power, like him, are now surviving on the masses of the poor citizens. Okay? Thank you for the program. Someone else goes on to say, quite lengthy, this is Ronnie from Mbale. According to the information provided by the Supreme Court ruling, it is decisive, and it's a step towards ensuring that Uganda's legal processes for civilians are adhered to strictly to the principle of fairness, justice, transparency. It compels the transmission from military to civilian judicial processes for civilians, thus aligning the Ugandan practice with establishing international human rights. And you continue to talk about various things there, and you talk about the temptations of overlooking it. The last two. Good evening, Timothy. Thank you for the show. I'm Simon. It beats my understanding. If a civilian, why do you need to have a gun? Should we allow soldiers to use guns on civilians so that they are tried in civilian courts? It's absolutely abnormal for people to commit crimes in the name of being civilians. Okay? Good evening, Timothy. This is 𝐒𝐲𝐬𝐵𝐻𝐻 from Bunga. The Supreme Court ruling is good, but the timing might look like it's intended to spearhead the release of 𝐒𝐻𝐵𝐻𝐻. The president bases his matter to show the potential revocation of the decision. So this looks like a show of power between the judiciary and the executive. Let's watch the space. Greetings to the intellectuals in the studio. Okay, let's take a quick break, and when we come back, we'll be finishing the last leg of the show, especially to 𝐒𝐮 to go for a break now.
Lillian! Lily flower!
A small seed.
The cedar bus of beauty, the power bank of my heart, the sugar of my milk tea.
I'm glad you're here. Today buy for us some chicken.
No problem. You can eat whatever you want. I had already ordered. How much?
122.
122? Now, what if I take this one and this one? And can I also borrow this one? How much now?
When your money is not enough, don't hassle. We're 𝐒𝐿𝐻𝐻 with MTN Momo. Use the Momo app or dial *165 *5# to add call with Momo Advance and pay.
On Thursday, 6th February 2025, Greater Masaka region will host the 44th Tarehe Sita anniversary celebrations. Tarehe Sita commemorates the launch of the National Resistance Army's liberation struggle on 6th February 1981. The annual event is organized by the government and the Uganda People's Defense Forces UPDF. It aims to honor the spirit of community partnership and Pan-African solidarity. The anniversary will be celebrated under the theme Celebrating Pan-African Solidarity and the People's Sacrifice in Struggle for Freedom and Democracy for Socio-Economic Transformation. Join us on UBC TV Thursday, 6th February as we relay the celebrations in real time. This is Uganda in 1986 and now. In 1986, when the National Resistance Movement came to power, there were only 7 commercial banks that were operational. Besides, there were other 4 credit institutions, including Centenary Rural Development Bank, that is now Centenary Bank, having been granted a license to operate as a commercial bank in 1992. By end of 2024, there were 26 commercial banks operational across the country. Before 1986, banking hours lasted between 8:30 a.m. to 12 p.m. This had been so since 1907 when commercial banking started in Uganda. In October 1987, the NRM government extended banking hours from 8:30 a.m. to 2 p.m. It was further extended to 5 p.m. weekdays. Saturday and Sunday, half a day. This is Uganda in 1986 and now.
Welcome back from that quick commercial break here on Behind the Headlines. My name is Timothy Nyangweso. We're discussing the Supreme Court ruling, the President's letter, the advice from the Attorney General, but also what's the way forward, especially that we have Ugandans languishing in jail with no warrants at all to keep them there. That's the discussion. You can follow it on our YouTube channel or our X platform, hashtag UBC Behind the Headlines, or go and text us or WhatsApp us on the number 0709 60 25 92. So many messages coming through. We'll get to them in a short while. But my panel is of land friends here. Helen Ndagire, who is next to me, Nicholas Opio, Professor Christopher Mbazira. I also have Honorable Medad Lubega Segona. And finally, I also have Honorable Fred Mukasa Mbide in the studio. We're discussing these patent issues. Professor, let me come to you. This seems like a collusion course for the executive and the judiciary. What do you make of it? Especially some elements in this letter of the President where he calls and says the Supreme Court, the matter of firearms of civilians being tried by the court-martial, this was a method which was used by freedom fighters to support the reinforcement of civilian judicial systems. Then he continues to say, it appears that some of the positive movements among our foreign-oriented judges, even in this matter. He continues and says, the Chief Justice ruled on the court-martial, the Chief Justice ruled that the court-martial could be used if adjustments are made here and there. What does this mean, as even the judges are celebrating or in a 26th conference? What does this mean for the executive and the judiciary?
It's not new to have a collision between the executive and judiciary. But what settles it is always the doctrine of separation of powers, which in our case, as is the case in democracies all over the world, is constitutionalized. The mandate of each is clearly defined, and one of the key elements of that doctrine is the doctrine of checks and balances. And it is not disputed that in the scheme of checks and balances, the judiciary is the most powerful, because it adjudicates disputes, it makes decisions with finality. It is even more important when it's the Supreme Court, because then that's the final court in the land that makes that adjudicates matters and defines the necessary checks and balances. But of course, many times the executive comes out to assert its domineering position. But what is most important is the Constitution. When you look at the report of the Constitutional Commission, it is very clear. The Ugandans were very clear on the position of the executive. They were very clear on the position of the judiciary. And what comes out clearly in that report is that we should have a judiciary that exercises checks and balances strongly. It's therefore unfortunate for the President to ignore that and to allude that the judges are foreign judges, to say foreign-oriented judges. Mind you, I think, if I'm not mistaken, the entire panel was educated in Uganda. They did their Bachelor of Laws in Makerere, if I'm not mistaken. So I don't know what the President means when he says they have that foreign orientation. And of course, the question of why did he appoint judges that have that foreign orientation. But the most important thing, as I said earlier, it is for Ugandans to understand that this is a decisive moment in our political situation where we have to be strong in terms of emphasizing constitutionalism, in terms of reminding everybody that we are bound by the Constitution, in terms of reminding everybody of their mandate, their boundaries, and how far they cannot go. The executive needs to understand that, it cannot survive without the other organs of the state. We know historically the executive has been domineering, but that is something that we need to move away from. And the Supreme Court decision, as all my colleagues have said here, apart from Honorable Mbide, who is not celebrating, hopefully by the end of the show, he will be celebrating. I think it gives us an instrument that we can use to start on a journey of entrenching constitutionalism, to start on a journey of entrenching a separation of powers and necessary checks and balances.
The Constitution is 29 years old, making 30, I think, this year. When you look at it, do we need, especially when you look at like the UPDF Act, articles that are really not in tandem? Is this a place where we now review our constitution, and has its lifespan ended so that we can be able to look at it? What does this mean for that?
When you read the decision, the problem is not the constitution. And hopefully the executive does not tamper with the constitution in the name of implementing the decision. Just as Nicholas said earlier, the risk is that the executive may tamper with the constitution in the name of implementing the decision, of course, which is unconstitutional. I mean, with the intention of undermining the decision. The problem is the act, and the court was very clear, very precise in terms of the sections that are inconsistent. The court was generous enough to make proposals, what it called advisory orders, in terms of what can be done to rectify the situation. Interestingly, the court even gives alternatives, various alternatives. So I don't think the problem is the constitution. It may have its issues in other areas, removal of the presidential term limits, the age limit, and things of the like. But in terms of the position of the military, in terms of exercise of judicial powers, in terms of the power of parliament to legislate and put in place subordinate courts, the constitution is very, very clear. So I don't think in this regard we should interfere with the constitution at all.
Thank you. Nicholas, when you, I don't know if you've had a look at the president's letter, and he says, like I was telling Professor, the Chief Justice ruled that the court-martial could be used if adjustments are done. We will be following up this point. And he goes on to give guidance on how it should be done. How easy it will be, how easy it is to try soldiers who have stolen army rations in civilian courts because of stealing. The offense is a penal code offense. He says the military court helped us to discipline the Karamojong. We cannot and will not abandon this useful instrument for the stability. The stability of this country is dependent on the military and the military courts? Is that what you're perceiving from this?
So the president's letter came hours after the judgment of the court. And the president notes in that letter that he had had a telephone conversation with the Attorney General. An Attorney General who on Monday said he hadn't read the entire judgment and asked Parliament to allow him time to read the judgment. So clearly the president was not properly legally briefed at the time. He may have made the statements in haste. He has made those statements, I think, before even speaking to the Chief Justice. So you would think that he spoke in haste, he spoke in anger. And I think for me, he makes what I think are false, sweeping allegations that this country is stable because of the general court-martial. Far from it. But I also think we must disabuse the president, as we should everybody else, who seems to be focused on civilian trials only as an aspect of this judgment. There is an urgent need for transformation of military justice in the country. And the court makes that judgment, makes that proposal, that it is also important for military men in uniform to enjoy the right to a free, fair trial before an independent tribunal. Because members of the UPDF are suffering in pain under that court. There is no due process in that court. For soldiers, it's even worse. I have done cases for soldiers going through that court, and I made a decision never to go back before that court, because in my view back then, about 4 years ago, that wasn't a court. And so the president should look beyond his obsession with the issue of civilian trials. Even his own relative, by marriage, Tumukunde, could spend 11 years before that court. Imagine what happens to an ordinary soldier. So the need to reform the military justice system cannot be overemphasized, and we hope that the president can look beyond his obsession about civilian trials and reform that system for the sake of his own soldiers. People who sacrifice serving the army deserve due process, deserve fair hearing, deserve better treatment than they are facing before that court.
Nick, are we looking at political challenges with legal lenses? Especially, the president says, as freedom fighters, this worked. The advisement from the Attorney General tells me that I can make adjustments.
His crying Maybe he hasn't also looked at the preamble of the Constitution. Our preamble gives the historicity of problems befalling Uganda pursuant to the manner in which soldiers were being treated. In fact, forming the basis for the establishment of army representatives in Parliament, almost major as a listening post, that where the army never got to know what was going on in governance, they used to establish coups d'etat here in Uganda. So if you do not sort out human rights levels of the military, then you are bound to be establishing another historical context of how governance will be established in Uganda by way of coups d'etat by the army that would in effect be denied their own fundamental human rights. Just like Counsel Nicholas has said, one of the advisory orders that were given by court included a proposal that even a military division could be established as one of the divisions of the court. We have an international crimes court, division. We can have that division. But for purposes that trials must be also hinged on the fundamental umbilical code of checks and balances, of justice and fairness, fair hearing, and it cannot be that simply because one has a job of a soldier, then one, of course, now all fundamental rights that accrue a human being are extinguished simply because you're a soldier. In my opinion, I think the president needed to address his mind to the advice given by court so that we can have the proper intent to progress with the military. Yes.
When we are doing death sentences, reviewing files for people on the death row,
yes,
we discovered that more than nearly half of the people who are on death row were cases arising from general court-martial and UDCs and other courts in the armed forces.
Mm-hmm.
But here's the bigger problem. The Constitution says no death sentence can be executed unless confirmed by the highest appellate court, right? In other words, you cannot be hanged unless the Supreme Court has confirmed your sentence, right? Many of them could not even get appeals to the Court of Appeal or to the Supreme Court because there were no records. So they were between the death sentence and really and being freed, and yet they couldn't be freed. And so that sort of situation led us to, at the time there were over 500 people on the death sentence that we had spoken to who didn't know what they were going to do. Prisons had no definite time to deal with them. This was before the Chigula case. And so the reform in the military justice system is one that is urgently needed and one that the court has assisted the president in looking at. So the president needs to look beyond his obsession, like I said, with civilian trials. The second thing is this, that you have, like the Chief Justice said, somebody's bodyguard in the army can become a member of that court and can send you to prison for the rest of your life, or even to the gallows. A bodyguard has no understanding of the law. The Chief Justice equated that to a lawyer being picked on Kampala Road and told to go to Mulago to carry out a heart surgery. He probably has no idea what the heart and the kidney look like.
I said, actually, I don't know the difference. I may not know the difference between the liver and the kidney.
And yet I am fairly educated.
And they are telling me, you can operate on the kidney. Then I might remove the liver.
Nicholas.
So those proposals are useful, and the president ought to look beyond.
But you know the other thing which is important, which was revealed in this case, was the discrimination.
Mm-hmm.
Yes. Because, first of all, there is nobody, whereas we have the DPP under Article 120 for the civilian prosecutions. In the military circle, there is nobody charged with the duty of prosecuting. There is somebody appointed as prosecutor. Now the prosecutor, the judges, and the judge advocate are appointed by the same person, the high command. What is so funny is in their regulations, they may reach a situation where they say, but we have found some difficulty with how to handle this case. They seek guidance
From the High Command.
From the High Command. Just imagine, they seek guidance from the High Command. As you noticed with the 𝐒𝐮𝐲 case, he was arrested, literally, by the judge advocate. He was, of course, sent away, tortured, etc. When he came back, they did not read for him a charge sheet. They read for him a judgment. Conviction and sentence. Not even mitigation. Look at this conundrum.
A lot of events that happened in December.
Exactly. You know, but let me tell you, I had gotten heads up that they had planned to arrest Aaron. Some people were saying, they go and arrest him from his house. Others were saying, from his office or on the street. Then others said, no, let's wait for him to come back, and we charge him for the offenses he committed the other time when he was there. And you know, even on that date, he was provoked by being denied access to the bar where he was supposed to work from. So I think the conundrum was, who decides who to take where? I represent Jamil Mukulu. He's accused of terrorism, all manner of horrendous accusations against him. He's in the civil court. Bobby Young and all those other young people of Noob, for putting on a beret, they are in the military court. So when do you decide who to take where? The arbitrariness in the discretion of an unknown person. By the way, the prosecutor in the court martial is a very, very junior person when you compare with the DPP, who has a duty of, among others, preventing abuse of court process. The prosecutor is supposed to be a shield for the citizens. Before you are taken and prosecuted, the DPP is supposed to look at the file and say, this one does not measure up. Unlike other places, the other side, where nobody looks at the file, when they bring a file and say, this one has been arrested on orders of so and so. For example, General 𝐒𝐿𝐿 was arrested by the CDF of the day. Tell me how this prosecutor, who has no protection under the law, is going to receive this file of 𝐒𝐿𝐿 and review it and say no. First, under what law? Secondly, he first salutes the person who delivered the file. Or if he is told to come and pick it, the kind of oath they take, it is an oath of allegiance to the commander-in-chief.
Okay, thank you. Nick, let me come to you. Reading a publication that had militarism and peace education in Africa that was done by �YESH in 1989.
Yes, Tandon.
Yes, it talks about when Idi Amin raised the military court to above the civilian court, but also came up to create what was called the economic criminal court there, that had people between 73 and 75. Yes, and he had people firing squad at the season. What angle do you see the president, especially with what he's saying? He has been given a get out of free card, if I could call it that, especially by the Attorney General saying the adjustments, by the Chief Justice, adjustments can be made. But we've also talked about amendments.
What did Amin's constitution provide?
No. We've talked about amendments. Yeah. We've also talked about the establishment that has made the CDF now almost the CIC now. And I also remember his tweets last year where he went on to say, if any police commander in the next year abuses my father, myself, or anyone in government, doesn't that concern that any one of us here
allows suspect? A person on a public meeting, on a meeting, to abuse, and you do not stop that meeting?
Doesn't that make us all suspects again, especially with all these playing around? And what ace does the president have with this in his letter, seemingly to direct us where he's going?
No. Intrinsically, Museveni is not a Democrat. I can tell you. He does not believe in legal processes And this is not the first time he has said these things about the judiciary. In 2005, when the Justice of the High Court gave bail to Dr. 𝐒𝐮𝐲𝐬 and subsequently got them rearrested, he said the same things about the court. He said nasty things about the court. So I don't think the president believes that power is devolved and shared amongst the three arms of government, so that in certain instances, it is not his call. I think he envies Idi Amin, who would rule by decrees and everybody would fall in line. I think the president issues edicts, issues orders. I think he doesn't believe we are in a constitutional democracy.
Actually, he has invented executive orders.
There's no such thing as an executive order. It's just a fancy press statement on a State House letterhead. There's nothing in law as executive order, because power is devolved. Prof talked about separation of power. Honorable Bide said the same things. Certain functions of state has been vested in certain arms of government, and the president cannot run rough shoulders. And you can see what they're trying to do structurally. Undermine parliament completely, so that decisions of parliament are taken in the caucus of the NRM. It's interesting, they're meeting on Friday. We would like to see what they're discussing. So this kind of things just undermine the constitution, undermines the rule of law. I think that the president needs to perhaps come out of his nostalgia of the 70s, of the Amin, decree issuing, order issuing presidency, and know that you cannot do that. We are under a constitutional democracy. And if he indeed has interest in proposing amendments as an executive, they can do so. But he must realize that those amendments are going to be subjected to scrutiny by Parliament. And if Parliament, by any mistake, pass what he wants to pass that we think is illegal, we'll go back to the courts, and the courts will strike it down again. That is the process. And I think that the president has to appreciate that we don't live in the 70s anymore. It's not Idi Amin issuing orders. Those executive orders mean nothing. The president is, as anybody else, governed by the Constitution. He ought to follow the Constitution.
Thank you. Helen, let me come to you. Already Professor hinted on it, but this doctrine of separation of powers, sometimes the greeting goes to pass the hand and it's at the elbow. Where is the intersection, where is the interaction, but also the sharing and the respect, the mutual respect in there?
So I would start with the point that good governance would require that the different arms of government operate independently of each other with the necessary checks and balances that the panel has discussed. So in this case, we can say that one can simplify it down to the level that by the mere fact that the framers of the Constitution put the different arms of government in different chapters under the Constitution, they intended that those should function separate of each other. However, as we've already talked about the principle of checks and balances, in this case, if I bring it to the case that we are looking at right now, the judgment of the Chief Justice clearly brings out the intersection or the interplay of the different arms of government. For example, when he makes advisory orders as to amending the UPDF Act to include the right to a fair hearing in terms of the composition of the General Court Martial, appointments to that court, and delineates the jurisdiction of the court, and also makes directions as to the manner of appointment of the members. So in this case, we realize that the checks and balances would come in, whereby, for example, if we are to look at appointments, we know that under the civil courts, that one does not just come and take up the position of a judge. They go through the due process. That is to say, you're vetted, you need to have a certain number of years of practice. You're vetted by the JSC, who recommend to the president to make such an appointment. So we see that the different arms come together to see that we have the best product at the bench. So in this case, we would also require that if that standard can be brought down to the General Court Martial, in that not only are we looking at a system where we amend the Act to provide for putting in, rather appointing competent people, people who have training to take up such a position. We are also looking at a system of vetting such persons. I would recommend that we take up or we adopt that system that is already in place. So in essence, we can't say that the doctrine is not in play per se, rather that the different arms of government are not operating in their independent mandate, but we can see, as the panel has discussed, certain stretches into the executive spilling over into the work of the judiciary, and that causing a problem to the implementation of the decisions. And yet we know that paramount to our judicial system is the doctrine of the independence of the judiciary. So I would say it's still a question of how and when the different key players can adopt to a new system whereby they realize that we are not only looking at the common good of one arm or the common interest of a smaller group of people, but we are appealing to the wider class of people, being Ugandans, that have entrusted us with the power, the mandate, and the functions that we exercise in our different roles.
When Nicholas hinted on it, when the president gets out to lambast the judges, when he gets out to talk about where is the intersection, where is the mutual respect, where do they get to, have a conversation that we respect the checks and balances that are between the three arms of government, but also, just to couple that, one of the advisements that comes from the Attorney General is on the DPP. Honorable 𝐒𝐮𝐻𝐫𝐞𝐦𝐞 has hinted on Article 120. How does that play out? How does that look like? What is the mandate of the DPP, and how will it stretch into what is now no longer the General Court Martial?
So I think Honorable 𝐒𝐮𝐻𝐫𝐞𝐦𝐞 put it clearly that in terms of the president's statements, he, like any other citizen, has a right to express what opinion he has concerning the judgment. So I would take it that he was exercising his right as a citizen to have a reaction to this decision that has just come up. But beyond that, it also goes to the executive functions that the executive office that he occupies in the country. We can't say that such pronouncements will have effect until we see what effect they are to have on the implementation of the judgment itself. But he is open to the advisories or the advisory orders that were given. He's also in talks with the Attorney General on how to implement the decision, how to come up with the proper amendments to the Act. So I wouldn't say that the opinion in itself is the end, or we can say that we can't look at it being implemented, since an opinion that is given concerning the decision cannot affect its implementation. And then looking at the issue of the DPP and how the Attorney General came in and advised on the fact that he's liaising with the office of the DPP to see that these matters are transferred from the General Court Martial to the civil courts, the office of the DPP. I would say that whereas we don't have any express law that gives the Attorney General the powers to carry out that function, this is where we see the interplay of the different arms coming in, because we know that we are coming from a court that does not have due process. For example, if we are to go by the UPDF Act or the UPDF regulations or whatever practice they have in place, do they provide for a system of transfer of those different cases to the civil courts? And the short answer is no. So who then can come in to see that this transition happens, and how quickly can the transition happen? So I would say that the Attorney General, as the principal advisor of government, is doing his role in seeing that these files are not only transferred, but that the DPP also takes forward and implements the decision, well knowing that the DPP under Article 120 of the Constitution has the mandate to oversee criminal proceedings in civil courts. So that's how I would view it.
Thank you. Honorable Mukasa, You know, when Honorable Segona and Nicholas spoke, I remembered the question where they asked the advisement from the Attorney General for the prisons to present a list, for the UPDF to present a list, so they didn't know who they were holding, but that is not the question. Is it a coincidence that this is happening in an electoral season?
You see, when I was growing up, academically, I thought I was going to, because I took science seriously during my initial stages, and I used to think probably I was going to become a doctor, having majored in probably, I had the moral base to think that I would major in gynecology as a special discipline. Part of the things that we studied include the calculation of distance, that you had to consider speed times time. Now, when you transfer such knowledge to what is happening in terms of the legal regime, for me it looks like it doesn't apply when we are actually running by way of a roundabout. You might not be able to cover a huge distance simply because, yes. So if you only calculate the amount of time spent by government and the speed with which they have actually spent, you can't come up with the distance covered in terms of justice. In my opinion, we are even actually, the appropriate method you can use is a pendulum swing. That is what we are using. We are faced with a pendulum swing in history, swinging from absolutism to democracy, and from democracy back to absolute dictatorship. In fact, what now Ugandans need to do, instead of clinging on the swing, if you gaze upwards, you will fall off. You will become dizzy and fall off. And that is what we are now facing. That is why, for me, I am not an active. Yes, there is a very big problem. I have failed to be an active enthusiast of any good judgment. Probably now, until judgment is given in February or thereabout, so that I could see whether we can now begin to use templates of certain neighboring countries like Kenya, looking at it in such a way that we feel all the powerful, called the government or the executive, can equally also be called to order. In Uganda, by the way, it's not enough for you to know who is a minister of anything. It might not be helpful in order for you to know who takes a decision over anything. Well, we have got what they call the eminence degrees. Now, those ones are persons wielding a lot of power without necessarily having a position of authority that is known under the Constitution. So we equally have such persons. Persons that can direct your release or arrest, despite the fact that anywhere in the Constitution they are not mentioned, or even substantive legislations that create authorities. So in Uganda, I think pursuant to decisions made by courts, we have of course had a wealth of authorities where courts have given a decision and the government has enacted a law that is seeking to definitely now counter the decision of court that had been given the circumstances. You remember the Public Order Management Act, which was again enacted pursuant to a decision that had been taken against the Police Act, I think section 32 under the 𝐒𝐿𝐻𝐵𝐵 versus Attorney General. So you look at the state fighting the very possibility that it should have used to evolve a legal regime that is actually democratically acceptable here in Uganda. So for me, I have a problem. And where we are getting, it is beginning to look like the president of the Republic of Uganda is working more with the kitchen cabinet than a substantive cabinet for purposes of evolving decisions. And he would wish that militarization of most of the departments of government is most likely going to be the answer. I told you one time here that he now prides himself in having established a choreography of institutions of puppetry as a method of government, where every institution should be headed by a puppet and he is the puppet master pulling the strings. And that if the substantive head is not a puppet, then the Twaisi now becomes the exact puppet that has got substantial direct line with the leadership of the country. Now, where the president thinks and feels that to him, justice and the proper trial includes a decision in his favor and excludes a decision against the whims of his own aspirations, then one would think, because now when he says that, yes, this country is not being led, is not led by judges, and somebody was actually, an axiomat also was quoting the Constitution saying, yes, it is true, all power belongs to the people. I said, but it is extremely important that one reads the constitutional provision. You look at it in extension. You must look at it, you read it, that the people also exercise such powers within the meaning of the Constitution. In accordance with the Constitution. Now the Constitution divides powers among us. It is not actually an absolute entity that is handed over to anybody, voted for any office. There is what we... Yes.
Even Ugandans, all Ugandans combined,
yes,
can only do what is permissible in the Constitution.
In the Constitution.
Not beyond.
So there is what we call unaniloquence. I do not want to use it while citing any name. But that is when somebody concentrates on speaking in such a way that there is no evidence of wisdom in what somebody is saying. and I do not want to attribute this to any leader. In fact, in English, you are allowed to use the word 𝐒𝐮𝐲 while refusing to mention the correct name of that person. So I think, in my opinion, whenever judgments are completely against the state, there is a 𝐒𝐮𝐲 that actually speaks in such a way that
I hope someone is keeping his
that speaks in such a way that you cannot guarantee that that person is actually wise. We must first of all know that the correctness of a judicial system lies in its capacity to issue orders that are actually against the most powerful of the land. If we don't adopt this, then Uganda is actually, they say when you look back and you start moving, that is where you will go. Now, if we want to establish 𝐒𝐻𝐻 here, obviously that is where we will go. But I wish that would be accompanied by the exactly, because the manner and style of leadership by Idi Amin is not exactly what is being established here. He believed that somebody had to do anything and there was no defense on failure or upon failure of doing it. But here, you could be accused of trying to do what you are doing other than the contrary that you ought to have done.
Okay.
Yes. So I think this government needs to receive this judgment. It is not that we feel that the judgment is the best thing in history, but I think it can be a starting point for us to believe that I think the judiciary is beginning to walk the judicial path that they ought to have walked along.
So, Fred, you are beginning to celebrate the judgment.
Okay.
No, I am getting persuaded to celebrate.
Let me read some feedback before I give the gentleman and lady their concluding remarks. Robert Mugisa Aboli says, greetings to the leaders and the seniors in the studio. I'm prayerful, but every time certain things go wrong in this country, I feel like releasing fire. I hesitate, however, because we have one Uganda and I cannot afford to see it burn. I choose to hang in there in faith, believing that something will turn out. Let's read the Constitution and all the laws in its entirety, okay? This one is to Honorable Segona. Honorable Segona, may you kindly accept to marry my beautiful daughter without paying dowry. It is my humble request. This is Asimwe from Busheni.
You can pass on the number.
Honorable Segona will pass on it now.
You've had the cathedral.
Thank you for the show. In the litigation, there is winning and losing. AG lost. It's trying to find ways to disapprove the Supreme Court ruling, which is unquestionable. This is Daniel from Entebbe. Thank you. Timothy, thank you for the show. I do not complain about things, but the independence of the judiciary is not possible. If MK says the Constitutional Court is ruling is just a mere gamble and not binding with orders, then what do you say? Okay. Good evening, Timothy, and the intellectual panel there. Even better than me, though beating up the bush, unless Ugandans are jointly mobilized to do the needful, we shall have no rule of law in this country. Okay? Lastly but not least, Timothy, thank you for the show. I think you made a mistake to host only lawyers on the panel. They tend to love to listen to their own words. When the president informs that the judges do not rule the country, you only amuse yourselves in conjecture, instead of lazy references to the Constitution which only exist in given context. Without agreeing or disagreeing, the Supreme Court, I dare say, it will only apply in a certain context that only acknowledges what is of the president. This is Julius Ankunda. And finally, Mr. President is also a human being. He's a person. All he wants is what he says and his opinion as a citizen of Uganda. Anyone who can submit or say what he's saying is reasonable. Thank you for the show. Thank you for all the messages that have come through, and we're going to do it a little bit different. We're going to make 2 comments, and I'll start with Honorable Mbide, come to Honorable Segona, Professor Nick, and finally Helen. You said, and also the arrest of the accounting general on the 60 billion haste there. Your comments on the 2.
You said?
You said has closed business, and there are people who have lost jobs. Some people have been told not to come back to work.
Yeah, of course, African leaders need now, first of all, to hold an emergency meeting on prioritization. It is very unlikely, actually it is foolhardy for any government to start telling its people that taxpayers of another country have actually concluded that they are no longer funding our own activities here, and accordingly they have done bad. It is important that we can now reprioritize our own to the extent that we can be able to ameliorate otherwise the budgetary problems that befall our own country. I think Uganda needs to style up. It is not enough for you to be arrested and accordingly taken to anywhere now that you know. It is extremely important that, first of all, the arresting entity is known, reasons are clear to you, they are arrested, and wherever you have been put, and the trial procedures and processes are as correct as the constitution of the land entails. The arrests by what we call the Haitians, I think you used to call them the Tontoni Machotes, the paramilitaries that are unknown to anybody. It means, for example, the same way they arrested the Honorable Segona some time ago, as he has just told us, up to today he cannot tell who arrested him, which offices they held, even why actually. It is still a logical impossibility for anyone to tell. That must stop if the country is to progress into a democracy that we all clamor for.
Okay, thank you. Honorable Segona, you had the privilege of Bank of Uganda. So the 60 billion heist, the accounting general arrested and some few people there, but also a comment on, you said, suspension of business.
Well, part of the events in the at Accountant General's office, the arrest and detention, actually that particular knowledge deprives me of an opportunity to express myself freely. I would want to see justice done to them. I actually, whether you arrest or not, I want to have the right people arrested. I want to have this money back. We are still proceeding with our inquiries, notwithstanding the arrests, as 𝐒𝐿, and for that reason I refrain from making comments in relation to that. But the coincidence that while Donald Trump is withdrawing his aid, we are losing 60 billion, okay? to fraudsters. In other words, money that probably we could have used to reorganize our economy and activities, yes, as Honorable Mbide said, is now being lost. It is a shame on us. We need to reprioritize, as his Fred says, because nobody has a duty to feed a neighbor's son. It is disturbing that it has happened, but it has happened. But as it happens, look at the African countries. They are all warming up to go and fight each other in Congo. And how much money are they going to use and spend in those places? Part of the reasons why we are broke as a country is because we do not know what to do. We leave what we are meant to do. We do what we are not, we don't do what we are meant to do. Instead, we do what we are not meant to do. I'll give you an example. Just yesterday, one of the contestants in Kawempe North, driving from our offices in Kamocha with a group of his people, was arrested. His team was arrested. Why? Because I think the ambulance had a siren on. Now, over 10 people are in police custody, awaiting prosecution. Hundreds of NUP supporters are in custody, even after the Supreme Court saying they are there illegally. What am I trying to drive to? Our misplaced priorities. Because we want to protect one person in power, we spend a lot of money, we spend so recklessly. And then you tell me that another taxpayer is wrong to withdraw his money. If we stop the reckless persecution, if we put our money into productive things, they tell us that the backbone of this country is agriculture. How much are you investing in agriculture and agricultural research? As we wind up, since you said the last take on this, to fellow Ugandans, this country belongs to us. Some of us are not lucky to have a second home. Some people can afford to mismanage this country because maybe they have a second home either by birth or by wealth or by descent or by passport. Some of us do not have that privilege. The duty, therefore, it lies on us to create the Uganda we want. Okay. Donald Trump told those Africans, go back and make your countries better, whether by prayer or by fasting. Do all within your means to ensure you have a peaceful country that you're going to bequeath to your children. Do not sit back. Do not relax. Let us not surrender to one man.
Okay. Professor.
Or woman.
Yeah, it's unfortunate we lost such a huge amount of money. To me, the most important thing is to see how this case evolves, because we've seen cases of that nature previously, and we never see the convictions. We never see the convictions, we never see the asset recovery, it never happens. It's unfortunate we are not privy to the evidence in the case. Honorable Segona here appears to be privy to the evidence in that case. He's withheld that from us. But we are the victims of that crime, actually, as Ugandans. And the ordinary scheme of criminal prosecution...
I don't have the evidence. I'm looking for it.
Okay, okay. you could be having bits,
investigating.
Bits here and there. But the point I'm making is that we are the victims of that crime. And as victims, we're entitled to step-by-step updates on the investigations. We're entitled to step-by-step updates on the evidence. The unfortunate thing is that sometimes these high-profile cases are, done and pursued under a cloud of secrecy. We don't know what is going on. We don't know what evidence the police has. After the arrest, I would have expected the police to come out and, held a press conference, told us how much evidence they have collected so far. Of course, they don't have to divulge all the evidence because it may compromise the prosecution. But for me, my disappointment is going to be if after 6 months, if after 1 year, we don't see a conviction, if after 5 years, we don't see any asset recovery from that particular case.
Okay.
As far as you said is concerned, I think it's a wake-up call for Ugandans. It is a wake-up call for those that make decisions on what we spend on. Just as Honorable Segona has indicated, we need to change our priorities and stop the wastage that we see so that we know we channel the money to sectors that actually matter to Ugandans.
Thank you. Nicholas.
The American Embassy every year releases a report. I doubt many people read it, called Our Report to the Ugandan People. It's supposed to be an accountability mechanism. If you read that report, you'll understand that these lies about Uganda being a self-sustaining economy is really empty. Let me give you 2 examples very quickly. When we last looked at HIV/AIDS figures, we discovered that 98% of every person in Uganda who is on ARVs is getting ARVs because of USAID money, not because of the government of Uganda investment in our health sector. We discovered 13,000 health workers in this country who are being paid directly out of funds from the US. Wow. And so any freeze of funds by the US does 2 things in my view. One, exposes the lies that we are a self-sustaining country. We are not. We are a country that is laden with debt. We are a country that is living on grants. All that we do in this country, in fact, in some cases, even recurrent expenditure, such as paying salaries and house rents for government offices, are even paid on sometimes grants. But our entire development budget is not funded locally. It's funded by domestic investment, by outside investment. And so this decision by the US government exposes that lie. The second thing it does is it has life implications on so many people. Yeah. I know young girls who are living on ARVs went to Murray Stopes to get their weekly supply of drugs, and they were told, sorry, we can't give you drugs. We don't know when we might be able to give you drugs. Their lives are now in danger, as are the lives of so many other people. On the arrest of the Accountant General, like the good Prof has said, we've seen this movie before. When Sam Kutesa was arrested, Mukula was arrested, Nyangweso was arrested, we have the OPM scandal, Agnes Nandutu, Minister Chitutu, Minister Lugolobi. It appears that the punishment is the arrest. It tends to fizzle out after the arrest. The cases tend to fizzle out, and there's no actual accountability, much less any recovery of the things lost. We pray and hope this is a different case, that actual criminals involved in these transactions are apprehended and the money is recovered, because it's Ugandan money. It's really sad to see that this is happening.
Thank you very much. Lastly, Helen.
I would like to add to what everyone has said, that the decision for USAID is basically giving us a chance to look inward and try and see how we can build our own sustainable systems as a country without heavily relying on foreign aid to sustain us, even in as far as important aspects of our lives are concerned. That is to do with the livelihood and the case scenario that Councillor Nicholas Opiyo has stated. So to give us time to work on our own systems and build a system that sustains not only a certain class of people, but everyone, even at the best levels. Then on the issue of the arrests, I would say that I can't comment on what I think might happen or what the current situation is, given that the information has not been made public. But what I can say is that I hope that in this we can see that the system does actually work, and that the other arrests that we've seen that they have cited have only been because of a lack of evidence. And if there is evidence in this case, I hope that it's pushed forward, and I hope that we see justice being done and accountability be given to everyone that is looking at what the next step is.
Thank you very much. Gentlemen and lady, thank you very much for coming, and we appreciate that you spent your evening with us. To the production team for making today possible, we really appreciate, and for you watching and everyone who sent the message through. Unfortunately, we couldn't read all of them, but we'll end with this quote. If you spend your time chasing butterflies, they will fly away. But if you spend your time making a beautiful garden, they'll come to it. Good morning.
UBC, inspiring Uganda.
On Thursday, 6th February 2025, Greater Masaka region will host the 44th Tarehe Sita anniversary celebrations. Tarehe Sita commemorates the launch of the National Resistance Army's liberation struggle on 6th February 1981. The annual event is organized by the government and the Uganda People's Defense Forces UPDF. It aims to honor the spirit of community partnership and Pan-African solidarity. The anniversary will be celebrated under the theme Celebrating Pan-African Solidarity and the People's Sacrifice in Struggle for Freedom and Democracy for Socio-Economic Transformation. Join us on UBC TV Thursday 6th February as we relay the celebrations in real time.
UBC, inspiring Uganda.
Trump suggested should take in Gazans aren't even remotely on board. They've outright rejected the idea of displacement and land grabs, but their responses, I have to say, have been notably measured and balanced, perhaps not wanting to risk U.S. financial aid. And the